And you're very welcome. 10th of December 2020. It's The Beautiful Truth with Fintan Dunn reporting. Folks, they're going crazy. Check it out. Trump's delusional rage hits boiling point as all 50 states certify Biden win on Boing Boing yesterday. It's all over, they said, and just Trump can't handle it. I mean, it's a done deal. It's finito, finished. From CNN, the state certification comes as Trump has baselessly claimed that the election was rigged and sowed doubts about the outcome of the presidential race. Yeah, absolutely. But haven't I heard this tune before? I have.
The walls are closing in. It seems every day now a new facet of President Trump's life, both personal and public, is being scrutinized for legal, ethical, even criminal wrongdoing, the breadth of which is really unseen in modern political history.
Absolutely. That's it. I've heard it before, too many times. But let's just check out some more of the reaction yesterday. Trump asks a Supreme Court to let him join widely scorned Texas election lawsuit. Yes, it was widely scorned there yesterday. Unfortunately, they're having to report this today. Texas lawsuit to overturn US election results backed by 17 red states. Ow, that hurts. That's right, bitches. The truth hurts. And 17 states. But of course, this is all nonsense. Republican attorneys general in 17 states, Trump won last month, joined Paxton in urging the Supreme Court to hear the lawsuit less than a week before presidential electors meet in state capitals to cast their ballots on December 14. The states are Alabama, Arkansas, Florida, Indiana, Kansas, Louisiana, Mississippi, Missouri, Montana, Nebraska, North Dakota, Oklahoma, South Carolina, South Dakota, Tennessee, and West Virginia. Obviously, they're all totally crazy. And they're just piling on this Paxton thing because Trump is encouraging him to do this because he's looking for attention. That's what it is. That's all that ever matters to Trump. He's just looking for attention. And in fact, the whole thing is nonsense. Let's just check out some of the statistical nonsense which is being put forward to the Supreme Court, according to Reason magazine, which wouldn't know Reason if it bit that magazine in the ass. Let's check the actual suit and let's check the actual reality. Because the reality, folks, is that, in fact, the Paxton lawsuit from Texas before the Supreme Court is a masterpiece. That's why 17 states have piled on, because it didn't take them long to read through the 154 pages and realize that this was gold dust. This is now a 17 states in the Federation, because it's a federal structure in the United States, which are questioning what 4 states did in the Federation. And so this is highly admissible at the Supreme Court. This, in fact, is exactly the kind of stuff the Supreme Court is designed to hear. But Google will not hear of this, neither will Twitter, because the Supreme Court is obviously only just one opinion. And the opinion that really matters is the opinion of big tech, controlled by the CIA and the globalists. But let's check out these ludicrous claims. And here's some text straight from the suit. I've taken it out of the PDF of the suit, and I'm just going to give it to you here. The probability, says the suit lodged in the Supreme Court, of Joe Biden winning the popular vote in the 4 defendant states, Georgia, Michigan, Pennsylvania, and Wisconsin, independently in each state, given President Trump's early lead in those states as of 3 a.m., is less than 1 in a quadrillion, or 1 in 1,000,000,000,000,000,000,000,000. For Biden to win these 4 states collectively, the odds of that event happening decreased to less than 1 in a quadrillion to the 4th power. The same less than 1 in a quadrillion statistical improbability of Biden winning the popular vote in the 4 defendant states exists when you compare his performance with that of Hillary Clinton. And now the probability is 1 in a quadrillion to the 5th power. To say that this is highly unlikely is to put it mildly, and that's what's in the suit. But of course, reason knows no logic in this case, and reason rejects all this without even reading it. On the 8th, David Post, commenting on this, the odds. I do know a little about statistics, having taught it for many years, he says. Yeah, very good. Yeah, so he's an expert, right? But it's a fantasy. Now, this fantasy comes despite the fact that he hasn't actually read the paper which supports these figures yet. But he knows in advance they're already a fantasy. However, he did go and read the paper, and now he's back with some more. Right? So this is a reasoned response to this suit and the improbability stats which have been quoted in it. And that reasoned response on further consideration is that, oh, it's still as ludicrous as ever. He says, I tested the hypothesis, right? And he goes through it in detail. So he says that, believe it or not, if the 2020 voting population had precisely the same party preferences as the 2016 voting population, Biden could not possibly have won. And if the mail-in voters had precisely the same party preference, Biden could not possibly have won. He writes, wow, man bites dog, who would have believed it? If my aunt had 4 wheels, she'd be a motor car. So he's saying that you're stating something that's nonsense. I mean, how can we know that they had the same voting preference? And therefore, this is entirely ridiculous. Well, dummy, how we know that they had the same voting preference is we can do statistical comparison of the voting preference in Pennsylvania historically and its coordination and synchronization with the voting preference in other states which have similar demographics. We can even adjust for demographics. So you see how facile some of the objections to this stuff have been. Let's move on to the meat and ignore those who are throwing rocks from the sidelines, trying to put the quarterback off. Okay, so further into the suit. Let's just look at their substantive argument here now, and this is a masterpiece. The argument here is that the state and local administrators' systemic failure to follow state election law qualifies as an unlawful amendment of state law. When these non-legislative state and local executive actors engage in systemic or intentional failure to comply with their state's duly enacted election laws, they adopt by executive fiat a de facto equivalent of an impermissible amendment of state election law by an executive or judicial officer. Translation, our suit covers everything dodgy that happened in that election. It covers the fact that the mail-in ballots weren't put through the legislature and therefore those were unconstitutional, those methods of collecting ballots. It covers the fact that they didn't run a proper election under normal legal norms. In other words, that the law is obeyed. One person, one vote, no messing around, no funny business. That's how you run a lawful election. And if you don't do that, you haven't got a lawful election. You never had a lawful election. And therefore, all of your votes there, that whole charade you went through, pointless and needs to be discarded by the Supreme Court. So these are powerful arguments. And the electors in Texas and these other states, if you like, are now being represented. So we have, I'll give you an example of an individual. We have Lynn Wood making essentially the same case to the Supreme Court now, that he, as a citizen of the United States in a state of the United States, was disenfranchised by the failure of other states to follow the proper procedures. Because he's entitled to stand on equal ground with electors in any other state, and his state is entitled to stand on equal terms with any other state. So these are very permissible arguments. And it's the electors of Texas who are being represented by the Attorney General of Texas, Tom Paxton, in his suit. He is standing there in the place of, impropriate, is it, of those electors before the Supreme Court. So let's go on with these arguments now and see the quality of them. The argument goes on. It doesn't matter that a judicial or executive officer sought to bypass the screening for voters in response to the COVID pandemic. The choice was not theirs to make. The right to vote is a fundamental political right because it underpins all rights. And government, says the suit, quoting a previous ruling of the Supreme Court, is not free to disregard the Constitution in times of crisis. That comes from Roman Catholic Diocese of Brooklyn versus Cuomo in New York, and a ruling on the 25th of November. So they're actually citing that ruling against Cuomo by the Supreme Court to evidence the fact that you can't just toss the rules out because there's a COVID pandemic going around. That's already been established constitutionally in the Supreme Court. Another telling argument. Also, there might be an attempt to defend this on the basis that, look, these are political decisions and you're getting the Supreme Court to decide the outcome of a political event, which is an election. Not true. There is a difference between a political right and a political case. So they hold that the argument is, there you go, we hold this challenge to an appointment presents no non-justiciable political question. The mere fact the suit seeks protection of a political right does not mean it presents a political question. That's just a play on words to say it does. So the difference is that who you vote for is a political question. The fact that you have a vote is a political right. See the difference? Exactly. They're covering all possible counter-arguments in these statements they're laying out. And these are just a small sample of the telling arguments which come from a much larger suit. And finally, I love this one. We're getting to it at last. I've been waiting for this. None of the looming election deadlines, they say, are constitutional. None of them. And they are all within this court's power to enjoin. Indeed, if this court vacated a state's appointment of presidential electors, those electors couldn't vote on December the 14th. If the court tells them not to, right? If the court vacated their office after the fact, the House of Representatives could not count on these votes on the 6th of January 2021. You see, they're saying that, those so-called deadlines, they don't apply. The Supreme Court is the Supreme Court, and it's the arbiter of this election when you come right down to it. There's no getting away from it. They go on. Moreover, any remedial action can be completed well before January the 6th, right? Even the swearing in of the next president on January the 20th will not moot this case, because review could outlast even the selection of the next president under the capable of repetition yet evading review doctrine, which applies in the context of election cases when there are as-applied challenges as well as in the more typical case involving only facial attacks. In other words, they're saying that even if Joe Biden was sworn in as President of the United States while these considerations of the Supreme Court were ongoing, he would not be secure in his position. And that's established in case law already. And they quote that to the Supreme Court. So, Wisconsin Right to Life, Inc., blah, 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 1992. Mootness, they say. In other words, a moot is pointless. He's president already. That's mootness. Mootness is not and will not become an issue here. On we go. To remedy Texas claims and remove the cloud over the results, expedited review and interim relief are required. December the 8th is a statutory safe harbour, and they're looking for the Supreme Court to stop this process at any and every point in the process. So now let's look at the timetable which they lay out to the Supreme Court, which would be appropriate, they say, for consideration of all this. If they grant administrative stay or other interim relief, in other words, if they say, hold on everybody, we're going to look at this, then perhaps they suggest December the 11th, then, which would be the plaintiff's opening brief, and that's their argument to the court, and any other states who might want to come in with amicus briefs, in other words, coming in saying, yeah, we're behind this. and then give the defendant states a few days to think about that. They could make their case on December the 17th, and any other parties who are supporting them could too. And then on the 22nd, we'd reply to what they said, and further to that, we could have further oral argument if needed, depending on how the court decides to play things. And that would take us neatly into the end of the year period then to actually hear the case. Now, I'm not so sure about that schedule. I don't think we will get that because the 11th is tomorrow, and I don't think they'll be presenting evidence to the Supreme Court tomorrow. However, I would expect that if the Supreme Court are inclined to hear this case, then they would make a move tomorrow, Friday the 11th, and we would get an announcement. And I'm not sure of the timing during the course of the day. There's political sensitivities and financial sensitivities in these issues, and there are also behind the scenes things that are playing into it. But all things being equal, I'd expect them to move tomorrow, the Supreme Court, if they're taking this up. And it's hard to see how they can't take it up, because this is 17 states in the Union coming forward and making legitimate points which are backed up by hard evidence about the failure of these other states to play on a level playing field. And YouTube's action, saying they're going to start taking down video content that makes claims about election fraud, that's panic, folks. That's panic. And it's a defensive move rather than an offensive move. They're trying to justify it by historical precedent. But it's clear that with 17 states coming forward, I'm not sure that's going to play out. But it does raise questions, and that's why I'd just like to give you the good news that in this big issue of controlled by intelligence agencies YouTube, which can be censored, versus LBRY.TV, which is a blockchain-based uncensorable platform, I know what side I've come down on. And da-dum, there we are. There's Fintan Dunn's channel of YouTube stuff up on LBRY.TV. All of them. All my videos. Going right back. They've all been synchronized, and my channel is now synchronized with LBRY.TV. So if YouTube does decide to do stuff, and this is terrific, all that stuff that they've synchronized over the past week or so, they've grabbed all my video content and pulled it off of YouTube for me. Thank you very much, guys. And as you see there, it's fairly responsive. LBRY, it's a very good platform, and the quality of what you get there is good. Let's just check the last video out just for fun. It's 6th of December 2020, and you're very welcome. This is The Beautiful Truth with Fintan Dunn reporting. That's it. With Fintan Dunn reporting on LBRY.TV, where you're going to be able to get me no matter what YouTube think of the content I'm putting up. So, tough luck, guys. And so, we're down to the wire, folks, on this one. And it's going to be historic tomorrow. In fact, the next short while is going to be very historic regardless of what happens. But I'm fairly confident of what way it's going to go. I think that the kerfuffle from the media and the denunciations, it's all they've got. This is playing out exactly the way we expected it to play out. It's playing out exactly as how I thought it might play out a few weeks ago when I told you that this wasn't over by a long shot. And nothing has changed in the interim. All we've done is secure more and more and more and more evidence, with more and more people realizing what just happened. All right. So that statement that came out yesterday, I don't know if you saw it from Google about Joe Biden, and it said that the emperor is most certainly clothed in the garments of great lure and attraction. The emperor is fully clothed and most certainly fully alive. And rumors to the contrary, spread by some young Trump boy, that our emperor is naked, are entirely without foundation. See for yourself the glorious raiment of the emperor. Observe the fine detail. These garments have been examined and certified by some of the most prestigious royal court experts. And the emperor is absolutely clothed in garments of a rainbow hue. And anybody saying any different, we're just going to ban their videos. All right, that's it for this edition of The Beautiful Truth. I'll be back with some more very soon, and I hope you can join me for that. But in the meantime, this has been Fintan Dunne reporting.